All right, ladies and gentlemen, karibuni tena to this edition of the One Mic Show. Ni furaha kujiunga nanyi wapenzi wasikilizaji. As always, we are streaming live on Facebook from Kilimanjaro studios outside Washington, D.C. We are also live on YouTube, so please remember to share our live streams. Now, later tonight in the social segment, we will have a conversation asking why Africans put a high premium on eloquence in European languages. Now, following chatter about a recent reality show on Netflix, is it fair to judge African artists by how polished their English is? Stay tuned for that conversation. Na bila kusahau, tutapokea mziki toka DJ wetu machachari mleta habari DJ OmoshFaya, na tutadunda kule viwanjani na Micah jezi yake nambari 7 mgongoni, akituletea habari za michezo. So moja kwa moja toka Kilimanjaro studios ni mimi mtangazaji na mwanahabari wako mpendwa Ali Badawy. Kwetu wananiita mteule na wengine mniite mjukuu wa Masai. Because I'm Kenyan by blood, American by design, Masai by choice. Sichagui, sikagui, na sibagui. Karibuni tena.
Now, let's talk politics.
All right, now this hour in news and politics, we are having a discussion on yesterday's Supreme Court's landmark ruling on the Building Bridges initiative. We'll have a conversation on the implications of the ruling and the impact it might have on Kenyans living in the diaspora. So stay tuned for that and more. And I'm your politics anchor, Ali Badawy. It's Friday, the 1st of April, 2022, and we're coming to you live from Kilimanjaro studios outside Washington, D.C. Please, please, please remember to subscribe to our One Mic Show YouTube channel and follow us on Instagram at One Mic Show. On panel with me tonight is Mr. One Micah Makawa. We have our resident DJ OmoshFaya. Micah will also be with us via Zoom. And our super producer is none other than Mubelo Bandio. And without much further ado, we are going to get started right away. Now, Kenya's current constitution has been dealt a myriad of challenges since its promulgation back in 2010. Now, following President Kenyatta's handshake with ODM leader Raila Odinga back in 2018, the Building Bridges initiative got launched. Now, the initiative culminated in the push for a popular initiative constitutional amendment codenamed BBI. Now, the BBI amendments were challenged in court by a civil society group called Linda Katiba. Now, Linda Katiba's challenge was upheld by both the High Court and a subsequent ruling in the Court of Appeal, which put the BBI referendum initiative on pause. Now, this brings us to a conversation today, which has to do with the landmark rulings that came from the Supreme Court yesterday. But before we get to the meat and bones of the rulings, I first want to pose a question to our audience and to the panelists who are getting ready. So I want you to all pay attention. And I think, like Micah is also available on the phone. So this one, I actually want to get started with Micah on this one. And the question that I have is, why should Kenyans living in the diaspora, talking about us, why should we care about Supreme Court landmark rulings happening back home? So Micah, salimia wasikilizaji and talk to us about this. Micah.
Hey Ali, good evening. Can you hear me?
Loud and clear, Micah, loud and clear. So we're here, we want to know why Kenyans in the diaspora should care about, like Supreme Court rulings happening back home. Just generally speaking, no specific reason needed, but just generally speaking. Why should Kenyans in the diaspora care about this? Micah, twende kazi.
Kenyans in the diaspora should really should care about the Supreme Court rulings in Kenya because, number one, the ruling that was actually passed today, or was it yesterday, was actually of a very high importance because it's amendment of the Constitution. We should be able to get to understand what amendments were in that Constitution, were supposed to happen in that Constitution, why they were ruled like that, and why the ruling came out. And basically, everything that is ruled in Kenya affects us because this ruling would affect our taxing, how we get involved in elections, in the elections, and also it affects some of us who want to go back home, people who think that they want to go back and retire home, people who are investing back home. And also by us being here, we still have family back home, we have interest back home. So we want to ensure that we know what's happening there for the best interest, and it serves both us and their interest. I hope I answered your question well, Ali.
Okay, asante sana Micah. And I want to know, I want to hear from the audience today. Sean Kanyede, karibu sana. Slay, karibu sana. I want you guys to maybe just tell me, do you think it's important for the diasporans to keep up with the day-to-day politics, what's happening in parliament, what's happening in the executive, but is it important for us to also keep up with what's happening in the courts? There's a lot of technicalities, a lot of things that people maybe don't understand. Is it important? So I just want you to drop down in the comments and say, like maybe what you think or what you feel about this whole process. There was a whole, 5-hour session on TV, 5.5-hour to 6-hour session on TV on this particular ruling. And this, of course, this is the culmination of all arguments that had been presented, before. So it was a very interesting listen. So I'd like to, get your views on this. And now here we know that the court ruled on 7 issues that emerged from the previous Court of Appeal decision that had effectively paused the Building Bridges Initiative referendum process. Now, the issues on hand included the applicability of the Basic Structure Doctrine, which we shall be discussing shortly. Then also they ruled on whether a president can initiate a popular initiative constitutional amendment. They also touched on the process by which new parliamentary constituencies can be added. The court rulings further included verdicts on whether civil proceedings can be instituted against a sitting president, the minimum thresholds for public participation, and also the number of IEBC commissioners required to constitute a quorum, which can conduct their functions. Now, this was among a number of other issues, so we want to stay focused today because quite a number of things that we're going to be talking about. And Slay here says, like Micah said, it affects us who live in diaspora. So I think it's important to be in the know of what's going on back home. But at first, I want to come to OmoshFaya. Kwanza usalimie wasikilizaji. And OmoshFaya has been doing some reading on the Basic Structure Doctrine. This was, like an aspect that was very confusing to a lot of people who are maybe hearing it for the first time. Now, the majority ruled that the Basic Structure Doctrine is not applicable in Kenya. So, Uno, please tell us what the Basic Structure Doctrine is about and its origin so that people can understand what the meaning of the Basic Structure Doctrine not being applicable to the Kenyan Constitution is. Uno, twende kazi.
So the basic, by the way, that thing really confused the hell out of me. Because I was trying to understand when they're talking about the Basic Structure Doctrine, and this was being argued actually when the lawyers themselves were actually presenting their case in the hearing.
Yeah.
And it confused the hell out of me because they're like, okay, Basic Structure Doctrine, and they were always mentioning India.
Okay.
So now in India, apparently, so Basic Structure Doctrine, in simple terms, is that there are certain things in the Constitution that cannot just be changed. They are more like permanent.
Yeah.
Ni kama umepata gari iko na frame yake.
Yeah.
All you can do is just add.
Yeah.
But in order
for the foundation of a house.
The foundation of a house.
Yeah.
You can't just go there and bomoa all willy-nilly.
Yeah.
And this results from a case in Indian that was in India in 1973.
Mm-hmm.
And I think it was about a lady who there was an property, and the judgment was 7-6, and it stated, well, in summary, that Parliament cannot just go ahead and make amendments all willy-nilly. You can't just go there and say, you know what, nimekuta gari, foundation, then you can adjust it all you want, however you want. There has to be, there's a certain bare minimum,
mm-hmm.
and the bare minimum is the Constitution itself. The bare minimum is you cannot just make changes as Parliament, because then that would give Parliament all the power, and they can just misuse it, and they can just do madhogodhanyo to it. So the idea is, in order for you to make changes, you have to first go to the people. You first have to go to the people. And that ideally was the genesis. Now it became one of the terminology that is being espoused all over. You cannot, there are certain bare minimums on the constitution. In order for you to make changes to the constitution, you cannot just, as parliament, go at it. So watu lazima kwanza wakuja wafanye kazi.
So in short, like there's some eternity or entrenched clauses that are unamendable in the constitution.
Yes.
But it's important to note that this ruling said that doctrine, which is a judicial innovation.
Yes.
It's not part of the constitution. It's a judicial innovation.
It's not, yes.
But the ruling that came from the Supreme Court said that is not applicable in Kenya.
Yes.
So everything is game.
Yes.
Anything can be amended.
Yes.
According to the ruling.
According to the ruling that was read by Justice Kome.
Okay.
Yes.
But now on this ruling, there was a dissent by Justice Muhammad Ibrahim, and I think on the document that we have, if you could just bring that dissent by Justice Muhammad Ibrahim, which was on number 1, on the number 1 ruling, if you could just scroll down for a little bit so that our viewers can get to see this, to get the meat and bones of what's happening. So let's go down. So you see, okay, on the reasons for the first findings, that second paragraph. So forget about the first paragraph. Now the second right there, where it says, there you go, very good. So you see there, it says dissenting. Uno, just read for us what Justice Ibrahim said.
Yeah, it says dissenting Ibrahim SJs agreed with the High Court and majority of the Court of Appeal that the basic structure doctrine is applicable in Kenya. He agreed with the High Court that fundamental features of the Constitution, which are to be identified on a case-by-case basis by the courts, could only be amended by the people in exercise of their primary constituent power. He further found that genuine exercise of primary constituent power can be identified through the 4 sequential steps prescribed by the High Court.
Okay, thank you so much. So you can take it down for now. But we just wanted you to see that, because this was now a dissent. This was a dissent of the majority. So the majority has already decided that basic doctrine structure does not apply in Kenya. And this brings, and for those maybe who also want to understand better that basic doctrine structure, imagine a house. There's certain parts like the foundation and the pillars that cannot be taken down. If you take them down, it's going to destroy the whole house, or it's going to permanently alter the character of the house. So what the dissenters are saying, what the dissenter is saying, Justice Ibrahim, is that there are certain clauses in the Constitution, if amended, it's going to destroy the whole character of the Constitution.
Just to provide kidogo context, when people are rebuilding a house, the structure itself, you can, there's load-bearing walls.
Yeah.
You cannot move.
You cannot move them.
No.
Yeah.
Not unless if Omosh is an architect or whatever, he comes in and lays down the law or whatever. But the gist is
you would have to change certain things, like put in some some cross beams,
and you'd actually have to even get some people come in, an engineer, whatever, the city, state, whoever is concerned, to come in, authorize and see, and somebody whose certification or his license would be at risk in case anything happens. So you can't just change it for her.
Okay. All right, good. And this ruling has actually, it brings in some interesting precedent, and we're going to be letting also Micah, give us his 2 cents on this, and Omosh in the studio. But it brings an interesting precedent in the fact that the majority ruled that these amendment procedures have already been provided for in the Constitution. So the Constitution does not need, a foreign doctrine, because sometimes these foreign doctrines are used to fill in gaps of ideas or issues that might be missing in the Constitution. So this was a very interesting ruling, because they went against that international precedent, which is very common, sometimes in Kenyan courts. Like in this case, they were bringing that Indian case. But the majority said that this ruling, this Constitution has enough provisions, on what is amendable and what is non-amendable, and we do not need an external doctrine. OmoshFaya.
You're looking for me to add to the external doctrine?
I'm looking for you to chime in on the conversation because umeingia, umechelewa, and and you're ruining the flow of the conversation.
It's April Fool's, bwana.
Okay, sawa. Let's go to Micah. Micah.
Guy over here.
See your kitu ishanga midday.
Let's go to Micah.
April Fool's is a whole day.
Who said so? Why are you fooling us now?
Oh, he's trying to fool us, Satan.
Okay, Mungu watu.
Ali.
Yeah.
Wacha turudi kwako wewe uko vitu serious. You were saying
No,
No,
we're talking about the basic structure doctrine, and this is one of those aspects that people had like some difficulty in understanding. I
think it's the ruling. It's just the overall ruling, like the wording that they have for the ruling, because when you look at I think I saw like three judges who ruled on it. But anyway, the way the wording is, it's it's that legalese that is used that throws people off, and we just need things broken down more simply to tell us, okay, like we did here.
No,
foundation,
it's just that
this, that, the other. Without this, and the law says that you cannot change this without actually having an amendment and or changing this particular thing in the Constitution. That's the only way that you can then now come in and start breaking up certain things. And I think that's the problem with Kenya, with a lot of the laws that we have. Go ahead, Micah.
But then there's like the example over here where the constitution in this country cannot be changed. Even if it's amended, it still has to retain the basic structure of it. Like, regardless of what you amend on that constitution, tuseme kama ile ama jambo gani upenda kutumia for them
second amendment.
Second amendment, right? Yeah. It can never be just scrapped away and thrown away. There will be amendments to it based on how we evolve as time comes, but there will never be a day where they say, okay, you're going to scrap this off, nobody can bear arms. It can never happen. So I think it's the same thing with just Kenya. There are those basic aspects of the constitution that cannot be amended. They're supposed to be like that. You can twist them, you can put wording around them, but there's that basic structure that's supposed to guide how the constitution of the country is written. And I think most judges felt like the BBI was starting too much into that structure of the amendment. It was like they were ripping away that law and trying to switch it away. If we follow how the Indian example explains it.
Now, if we if we look at this first ruling carefully, this was actually a pro BBI ruling, and I know maybe some people may not like hearing this. Because and here's the confusing part. That basic structure doctrine, the ruling was that it is not applicable, meaning the Kenyan constitution does not have a basic structure. It's not applicable. It cannot be used.
Gotcha.
Justice Muhammad Ibrahim dissented and gave his reasoning, because the reasoning of which came from the High Court, because this went through the High Court first, then was upheld by the Court of Appeal. But this ruling here kind of overturns that, meaning that the High Court felt that to alter the basic structure, you need to go through a constituent assembly process, like the process we went through before the the 2010 promulgation was done. But now the Supreme Court is saying no, there's no, there's no requirement for constituent assembly. This can be a basic structure doctrine doesn't apply, because now the argument comes also which part is the basic structure and which is not, which sometimes might not be very clear. And that's why this doctrine, the majority felt that this doctrine is not applicable in the Kenyan constitution. When we come to America, because the American example is what people might be familiar with, the thing about the American constitution, it's one of the first, modern democracy constitutions that a lot of constitutions, look up to. But it is one of those constitutions that is the most malleable. Gun rights, for example, the one that Micah was talking about.
Mm-hmm.
Here's the interesting thing. that was actually an amendment. It wasn't even part of the original constitution. It was an amendment. You know, the first 10 amendments in the U.S. Constitution were kind of like the Bill of Rights, and those ones came, you know, like a few years after the Constitution, you know, like came in for America. But now the interesting thing about those amendments is that you can create an amendment to amend an existing amendment. Here's an example. Remember, there was a time when alcohol was made illegal in the U.S. via constitutional amendment. You know, I think it was in the 20s or in the 30s. I can't remember the prohibition. Yeah. But it was reversed by another amendment. You know, so the American Constitution, and I think people look at these American precedents and try to bring them in Kenya, and this is where the court was asserting itself and saying, you know, like, we have our own solutions. We don't have to follow these foreign doctrines, which I think presents a very, this to me was the presentation of Martha Kome's court, because previously we had Maraga's court, and previously we had Mutunga's courts. Mutunga's courts, in my opinion, was status quo, let things stay the way they are. Maraga's court, in my opinion, was Zua Rabsha, turn everything upside down. And to me, Martha Kome's court right now is looking like it's right in between the two. You know, turn it upside down if it needs to, keep it status quo if it needs to. And this ruling
and use the law as it's supposed to be used.
And use the law as it's supposed to be used, and also use the judicial processes as the Constitution, with the rights that the Constitution has bestowed upon the judiciary. So I want to remind the listeners that you're tuned into the Politics Hour of the OneMic show. We are talking about landmark Supreme Court rulings that has halted the BBI process. Now, later in the hour, we will be talking about why the courts invalidated 70 new constituencies that the BBI wanted to create. So I want you to stay tuned for that. Then please remember to share our live stream and like our Facebook page. We are also active on both Instagram and YouTube. So please follow us, subscribe, and keep spreading the word. But before we continue with this great conversation, Uno, please tell us what we have in store later tonight in the social segment.
It's very simple. Do we put too much emphasis on running English or being fluent in English and surviving and now I'm trying, you know, and managing my challenges in English?
Okay, that's going to be in the social segment, you know, like we'll be talking about, you know, like the emphasis that African people sometimes place on the eloquence of European languages.
Let us say East Africans.
Yeah.
Kenya, where are you?
East Africans, I think French West Africans too have that issue. You know, you'll find them, you know, laughing at the French of people from this other country. You'll find, you know, like people from Ivory Coast laughing at the French, or people from Guinea.
Oh, really?
Yeah, it happens also with other European languages. Yes.
Oh, snap.
Yes, that happens.
I thought it was just English.
Yeah, they don't have the right parlez-vous français.
Yeah.
Oui, Pepe le pied, monsieur le directeur. Sorry, go ahead.
So yes, so we wanna continue here. Rasvik karibu sana. Luis Muya karibu. Ras says the layman thinks it's Raila and Ruto flexing muscles. And that's right. You know, unfortunately, the media for a long time has kind of, you know, like framed the narrative as this versus them.
It's actually been pushed really as UK Rao versus Ruto and others.
Yeah, that's how it's been framed, and that's why,
which is a whole bunch of nonsense. But
and that's why, you know, like I had my issue with the way also the media was covering this, including the news gang on Citizen, who are usually very good and candid, but I'm going to talk about later, you know, like my feelings about how the media covered this and why there's one side that actually thinks that that they've won, but when you look at this ruling in detail,
totality,
it doesn't reveal that. Like that first ruling, the basic structure doctrine that we just talked about, that was a pro BBI win. You know, like whichever way you want to look at it.
Yes,
it said that you know, like those who say that you can't, you know, like create a prime minister, because that's what, you know, like the people who brought in the case were saying. You can't start creating a prime minister. You can't start creating an office for official opposition. But what the ruling says is that you can actually do that. That's what the ruling said. It says that you can actually do that. But the killer blow to the BBI process as we know it was the ruling number 2. And the reason why I'm saying the BBI process as we know it, I'm just meaning, you know, like this process that had culminated and came up to court. What effectively killed it was ruling number 2, which was actually a split decision. Now, the majority ruled that the president cannot initiate constitutional amendments through a popular initiative under Article 257. And I will be explaining later why I refer this ruling as the killer blow to the BBI process. So, Watu Pro BBI, I want you to listen to this carefully. When I say killer, it means that just that process of that started from the handshake, that's what has, and it doesn't mean that you know, like the pro BBI people, if they win, they cannot restart this process under another name, you know, after the election. So I want to be very clear on that.
Why are you saying under another name? Why can't it still stay as BBI? Or are you saying that if it stays as BBI, it's still going to have the same context?
It can still have the same name, but the process, this process that culminated in a bill, so that bill has already been declared unconstitutional. The bill that actually went to Parliament, what was being passed around, the county assemblies. So that right there, that day is dead. So even if they give it the same name, they have to create a new bill. It has to be a new process.
Got you.
Yeah, but now I also want to engage you a bit, OmoshFaya, on this, and I want you to tell us, you know, there was the popular initiative under Article 257, because the ruling said that the president cannot initiate constitutional amendments through a popular initiative under Article 257. And of course, it was very obvious that President Uhuru Kenyatta was all over this. You know, his fingerprints were all over it. But what is this popular initiative under Article 257? Omosh, talk to us about that.
So the popular initiative says that basically an amendment to the constitution may be proposed by a popular initiative signed by at least 1 million registered voters. So basically, in order to meet the threshold of coming across with a popular initiative, you need to have 1 million registered voters bring this popular initiative as an amendment to the constitution. It can come in 2 forms, either as a general suggestion or a formulated draft bill. If the popular initiative is in the form of a general suggestion, the promoters of that popular initiative shall formulate it into a draft bill. And then the promoters of this initiative shall then deliver the draft bill and the supporting signatures to the IBC commission, who basically will verify it. They'll sit down, they'll take a look at it and make sure that those 1 million voters or registered voters actually are there. And once it passes the IBC commission and they're satisfied with the initiative and it meets the requirements of the article, then it's then pushed forward. It's then submitted to the county assembly for consideration within 3 months after the date it was submitted by the commission. Then once the county assembly approves the draft, within the 3 months after the date it was submitted by the commission, the Speaker of the County Assembly shall deliver a copy of the draft bill jointly to the speakers of the 2 houses of Parliament with a certificate that the county has approved it. If the draft bill has then been approved by the majority of the County Assembly, it shall be introduced in Parliament without delay. A bill under this article is passed by Parliament if it's supported by a majority of the members of each house. So if Parliament passes the bill, it shall be submitted to the President for assent in accordance with Article 256, Section 4 and 5. So if either house of the Parliament fails to pass the bill, or the bill relates to a matter mentioned in 255, Section 1, the proposed amendment shall be submitted to the people in a referendum. And with the necessary articles that apply and any necessary modifications to the referendum under clause number 10. So in essence, from what we are being told is that, you know, there was by this particular popular initiative, it seems like basically what was happening was that the president cannot initiate
the process.
The process.
It has to be initiated by the people.
It has to be initiated by the people. However, the dissenter or the person who didn't agree with this was Justice Njoki Ndung'u. And Justice Njoki Ndung'u was basically saying there's nowhere in this Article 257 that it says that the president cannot initiate it. And then what else did she say? Then basically what she was saying was that she was using Articles 132 and 141 of the Constitution that says that part of the powers that are delegated to him as a democratically elected representative of the people under Article 1 of the Constitution allows him to actually exercise those particular powers, and he can initiate or move constitutional changes on behalf of the people who he's basically representing. So she basically dissented with the majority, even though the majority was saying that the president cannot initiate it, and that's why Ali was saying that it was a killer because she was the only dissenter.
No, she was not the only dissenter. There was also Justice Lenaola.
Oh yeah, Lenaola. Yeah, so
Isaac Lenaola.
Yes. Even though, well, he agreed with the majority that the popular initiative is a preserve of the citizens to the exclusion of the president. However, in his view, he was saying the initiation of the subject amended bill should have been done. Basically, what he was saying was that the bill was amended, that the initiative was basically done by the BBI National Secretariat, and not the president.
And not the president.
Basically, he was separating the president from it, and he was saying it was the BBI National Secretariat who did it. But the issue was on the president, and so that's basically, in essence, what killed this. So I think, back to your point, the people who brought this about, it can be brought about again, and this time do it differently. Don't use the president. If I were them, I mean, even though they're saying that the president, I would do it a different way if I were them. But hey.
But here's the interesting thing. Of course, the ruling the ruling here was that a president cannot initiate a constitutional amendment, and the majority already felt that it's a president who initiated this. So regardless of whether they allowed the basic structure doctrine, that in itself, the president being there, already killed any prospects of BBI moving forward. So to me, this was the killer blow to the bill. I see here Tommy disagreeing, with the dissent of Njoki, and Tommy says, let's not forget that Njoki has no judicial philosophy. She will rubber stamp anything Uhuru does, and that's Tommy's opinion.
But prior to that, he says the basic doctrine does not apply because the Constitution itself says it.
Now,
I'm just curious, where?
No, the Constitution doesn't mention, the words basic doctrine. Remember, a basic doctrine, that basic structure doctrine, is a judicial innovation. And these innovations come about when there's a gap in what the Constitution has said on an issue that the Constitution doesn't explain. So I think what Tommy is saying here that the Constitution does is that the Constitution, from Articles 255 to 257, it outlines the three different ways in which you could initiate a constitutional amendment. That's what the Constitution does, but the Constitution doesn't necessarily say that the basic doctrine does not apply. The basic structure doctrine is a judicial innovation that is brought about when there's a gap and now is being used. It was upheld in the Supreme Court of India, and that's the reason why it's applicable in India. Because remember, Supreme Court rulings are as good as law. So today, yesterday, the Supreme Court of Kenya say that this doesn't apply. So now that's the law, it can only be overturned by another Supreme Court ruling, which is another interesting thing about how the Supreme Court functions.
So are you saying this is the interpretation of the SCOK?
It's an interpretation, but if it's law,
Correct.
once it's a ruling,
they made a ruling, yes.
Yeah,
it's their interpretation of it.
Yes,
regardless.
And that's a job of a Supreme Court. They're supposed to adjudicate on matters that are not clear and on matters that people are disputing on the Constitution. Now, to me, I see, what Tommy is saying about Njoki Ndung'u, but I find, I find her reasoning, very interesting, and I think
Tommy should call it.
It's something that we should contemplate about. It's something that we can contemplate about, because Njoki Ndung'u says she found that that the president can initiate constitutional changes while exercising his constitutional functions under Articles 132 and 141 of the Constitution, as well under the power delegated to him democratically as a democratically elected representative under the people under Article 1. Because
Ibu, repeat that again so that people can get,
so
that they can grasp what she was trying to.
Because, and again, here we are trying, you know, like we're not on this side or that side. We're just trying to break down these things so that we ourselves
trying to understand it from a layman's
understand. You know, so the reasoning is that the president can't do it because, or rather, the president can do it because he has powers delegated by the people by the act of electing him. Has delegated. That means that the people who elected him have delegated their power to him to make decisions on their behalf. So that was the reasoning of Njoki, and of course that was in the minority, and it wasn't. And then she also points out that Article 257 has not explicitly mentioned that a president cannot take part in the popular initiative. So that's just interesting. And then Lenaola, his disagreement was different. He was agreeing that the president cannot take part in the process, but his claim was it's not the president who initiated the process. It was Junet Mohammed and was it David Waweru who are the BBI National Secretariat.
Yeah.
So that was the other part that actually was I found very interesting, and I know here Tommy disagrees with me. And then Tommy further says there are also 2 pending bills currently in Parliament that give instructions on how a referendum is conducted. This will come to play in future. Yeah, so that we also don't have a referendum bill, so that's an interesting point. Okay, so here we go. Yeah, so this is very interesting. But now this was the part. This second part was the killer blow, in my opinion, to this process, because now it just means that the BBI process cannot continue as currently constituted because it had the president written all over it, and that was the majority ruling. Now, the third ruling was actually one of the 2 unanimous rulings, and the verdict said that the amendment bill, which allocated an additional 70 constituencies, was a late addition and was not subjected to public participation, which thereby deems it unconstitutional. There was the 4th ruling, which was the other unanimous ruling. It said that civil proceedings cannot be instituted in court against the president or persons performing functions of the office during their tenure in office. Now, on this particular one, I wanna engage Micah on these 2 unanimous rulings. The one on civil proceedings against the president is straightforward. You know, like you can't sue a president in a civil proceeding while he's still in tenure. But the one on allocation of new constituencies is a bit interesting, because we know that IBC is the only body that's constitutionally mandated with the task of boundary delimitation. Now, the unanimous ruling, however, did not mention usurpation of IBC powers. It only invalidated the clause on new constituencies because of a lack of public participation. So it's very interesting to note. Let me repeat this point because I want guys to pay attention to this, because these rulings are going to be used in the future and people are going to start crying ABC. So the unanimous ruling, so the ruling was that the one that was against the one on allocation of new constituencies was I mean, of course we know that IBC is the only body that's constitutionally mandated with the task of boundary delimitation, but the unanimous ruling did not mention usurpation of IBC powers. It only invalidated the clause on new constituencies because of a lack of public participation, because these 70 constituencies was added. It wasn't part of the original process. It was added, you know, like when this bill was going to Parliament. So it was not subject.
It was slipped in and it was never given to the public.
Yes, it was never given to the public.
Gotcha.
So that's the reason why. But they did not mention that IBC is the only body that can do this. So to me, that's kind of a loophole that gives other bodies like Parliament the right to create constituencies in future. But let me hear what Micah has to say on this. Micah, give us your thoughts on this.
So, my thoughts on this are like, right, exactly there, that was a rule that was intent to hold the integrity of the IEBC as an independent institution, and also to uphold what its value is supposed to be. Now, as you said, again, I was looking at the wording when we got this info, and I was looking at the wordings, and as you say, there is a loophole there. Yes, it's a win right now for the anti-BBI, people who don't support BBI, but there is a loophole whereby if something was put in a referendum and there was a collection of signatures, that should constitute as public engagement, and that gives Parliament the power to go ahead and create new constituencies or reshuffle the constituencies as they are right now. What I'm trying to think here, can this be in turn used in a form of gerrymandering in a Kenyan sense of wherely? Because let's say the constitution comes and say that you have to form a government, you have to control a certain number of constituencies, certain numbers of MPs, and you realize that if you divide a certain number of stronghold constituencies in your stronghold, they can give a winning party that number to get there. I just feel like this is something that now that people know and is exposed, is something that political parties might take advantage of. If let's say the president of the ruling party feel like they're losing grip on parliament, they can use it to their advantage. Or the opposition feel like they want to take control of parliament, again, they can use it to their opposition. So for me, this is one of those rulings whereby it shines a light, but then how do we get to close that loophole and allow the formation of constitutions to only happen through IEBC by itself and not other bodies that can be able to go ahead and do it? Because here that statement on how that what am I trying to remember here? It has to be a popular initiative in the form of a general suggestion, right? Like it's something that people need to either go to. They either go to. Okay, sorry. Yeah, this is where I got it. So it says that. What am I trying to think here? Why am I'm not getting it. All I'm saying is this, Ali. The fact that they say that if they take it to get more public opinion, a referendum can allow a body to selfishly enact this in their favor, like parliament. And that parliament usually is depending on who's controlling or who's not controlling. But this can be selfishly used again to gain political favor in the country. That's what I think.
Now, piggybacking on what Micah said, like here we're trying to read in between the lines. Because like in Kenya we've come to a culture where people like don't like reading, they like sound bites, and then when things happen in future they're like, oh, how come nobody ever told us? Now this ruling and this right here that we are reviewing is the media summary.
Yes.
I don't know whether the courts have released the long ruling. Those long rulings are hundreds and hundreds of pages.
No, they haven't released it.
Yeah. So I'd like to see, especially on this part, I'd like to see, because on the 70 constituencies, to me, my thinking was, like the court is gonna say, oh, it's only IEBC that is mandated by the constitution to create the new constituencies. But now what they said is that through an amendment, popular initiative, parliamentary initiative, new constituencies can be created outside IEBC, because the only fault they gave to the BBI was not on trying to create new constituencies through the amendment. The only fault was that there was no public participation. So I think that's an element that people need to pay attention to, that I haven't heard this being talked about a lot, you know, like in mainstream media. And that's why you have to come here to the OneMic show, because we don't talk mainstream stuff all the time. So that's something that I think people need to pay attention to.
And let me also add, I think, you know, when the arguments were being made, because guys were talking about, and you know, guys when they had the hearing and people were trying, the appellant and the guys who are the guys who were for and against, you know, they're using, you know, like the doctrine and whatnot. Of course, we're fascinated by the wording and I guess they have such a short time to present their what their defense is, or what to support the supporting arguments. You know, but also even when the ruling is coming out, you know, and trying to sort of make it maybe palatable, you know, because there's a lot of jargon in there, you know, it also, you know, it's one of those things that I think, you know, we should actually take time to sit down and listen, because you're seeing the workings of the Constitution. You're seeing how the 2010 Constitution, how it's working, how it's supposed to work.
Yeah, it's coming to life.
It is alive in front of your eyes. You know, when you have the justices over there and the lawyers are coming in and they are quoting, you know, Section 257, this, that, the other, and whatever. You're seeing how, you know, it's like opening up the engine, and then you're seeing, you know, the rotary, the whatever, the valve stems, the pistons, whatever, how they work, you know, and the logic sometimes implied, you know, like now, for example, in as much as you're saying that there's a loophole, chances are they left that open such that when it is brought back, it's going to be brought back. And maybe Tommy can comment, you know, being that he has done law, you find that if and when it is brought back, or they come back to it, they probably will have already an established, what do they call it, precedent. Okay, we have an established precedent, but now we're going to interpret what we think this means, right? So like now that one of saying that the constituencies, IEBC is supposed to be the body that is mandated to do that
with the existing constitution.
With existing constitution.
Yeah.
Hiyo ni job yake. But I think based on whatever was presented to the judges to argue, they stayed within that periphery, within that window.
Yes.
Right? But if somebody brings the idea that, okay, maybe, you know, based on your assumption, because it's a very good assumption, by the way, the judge will be like, no. The Constitution says even the IEBC, the law, they are whatever governs them, states, they are the ones responsible for this. Has that change been made to make them different? No.
But now what they're saying is that, because an amendment is essentially a change to the Constitution.
Correct.
Yeah.
Correct.
So they're saying through an amendment, you can create new constituencies.
Yes.
They said that without saying it, because I feel like if you could not do that through an amendment, they would have explicitly said it. But they say the only reason why they tossed that thing of 70 constituencies, why they declared it unconstitutional, is because it did not involve public participation, and not because it was being amendment. So this movement of one man, 1 shilling, 1 vote, it stays alive at the expense of marginalized, you know, like counties and communities, because the 1 man, 1 shilling, 1 vote paradigm argues that you know, like money should be distributed, CDF money especially, should be distributed to constituencies, and also the money that goes to counties should be distributed based on the population, purely. And of course, that's going to give an advantage to the most populous counties. But then, you know, like the CRA formula that exists right now, the Commission for Revenue Allocation, you know, like factors in population to a certain extent, factors geographical size, factors marginalization. It has a lot of elements.
Kuna madhafu hapo.
Yeah, kuna madhafu inatumika, and marginalized communities where, you know, like since independence, maybe they've not had roads, they've not had schools, get, you know, like that advantage of where per person they're getting more money. So here this is an argument that the 1 man, 1 vote, 1 shilling, or whatever that's called, people need to bear in mind.
And I hope that this conversation, even here on the OneMic show itself, starts getting people interested in what the Kenyan Constitution does. Fungua, Soma,
It's a very complex, interesting document.
it is.
Yeah, it's a document that takes different shapes and forms depending on what issue you're looking at. But one thing that I will say, it was very well written. I mean, it has survived attempts to mutilate it, and this right here, this presents a very interesting turning point.
And the judiciary has actually stood its ground.
Yeah, they've stood their ground,
In
because
as much as they have been pelted and shown Madhogadhanio.
yeah, because it's been some of this pelting has been an existential threat to them, so they've been forced to do that. Now Stephen Bati here says, I think we need to give utmost credit to the group Linda Katiba. They are the champions of this initiative. Politicians took over the limelight, but they, Linda Katiba initiative, are trying to protect the constitution from mischief from politicians who may want to use parliament to change the constitution. Per my opinion, from watching Newsgang on Citizen TV and other channels. Yeah, so Newsgang always do a very good job in just breaking down, what people need to understand. But I feel like this time on this one, they kind of failed a bit in highlighting, they may have mentioned it, but just highlighting the fact that out of these 7 rulings, there was one that was indecisive that we're going to talk about towards the end. But out of the 6 rulings, there was this number 2, which was death to the BBI process as constituted. But out of the 6, 4 means 4 of them are pro-BBI, meaning that, after election, if the pro-BBI team wins, they can restart this process.
They actually did that. And Linus Kaikai actually said something that was very interesting. And he equated it to this. Konambuzi. You've slaughtered it.
Yeah.
So the 4 things that were left, he equated them to having the hooves and the horns. Nothing that you can say is tangible and meaty when it comes to the decision. So even those 4 things that survived or whatever, and Gashuri's also equated it to having a car, but the engine is not there and the rear tires are not there.
And I think that's where they misled people.
No, I'm talking about today.
Yeah,
I'm talking about the whatever.
The news game. That's what they said. Essentially, what they were trying to imply is that this thing is completely dead, and it is
legally.
Dead. And it
legally,
is,
per the ruling yesterday.
And it is dead
as it stands, as it is right now, as it was the BBI.
As per the BBI process was.
Yes.
But nothing is stopping them from getting a whole fresh new goat after August and just starting to slaughter it. Nothing is stopping them from doing that.
They say
based on this ruling.
Yeah, they did. Yeah. They did that.
So nothing is stopping that. So that's what anti-BBI people need to understand. So I think they were fixated so much on the process being dead.
And I also think the problem was like Omosh said when they were saying, when it was when they made it to be a Ruto, Raila, UK, whatever.
Yeah.
You miss, is it the forest for the trees? What you miss in essence what the BBI is, what the intended purpose of it.
It's been politicized.
When they say that it was hustlers versus the dynasty, that is where the BBI was lost. Yeah, that is where it was lost. That is where everything just went.
Yeah,
south. It's good politically, it's good to politique, but in the essence of politicking, I can assure you, close to 80% of Kenyans don't know what the document has.
Yeah, and Leo, we've really gone over time, but we really need to slice this down. So we're gonna take a few more minutes. I want to remind the listeners that you're tuned into the Politics Hour of the OneMic Show. We are talking about the landmark Supreme Court ruling that has halted the BBI process as currently constituted. Now, later in the hour, we will be talking about the unconstitutionality on some laws passed by Parliament. So stay tuned for that. Then please remember to share our live stream, like our Facebook page. We are also active on both Instagram and YouTube. So please follow, subscribe, and keep spreading the word. But before, we get to the conclusion segment, Micah, please tell us what is in store for us in sports later tonight? Micah.
So today in sports, we're going to talk about soccer, and a lot of soccer. We're going to talk about the African qualifiers, Cup of Nations qualifiers, and how they happen. We're going to talk about the African World Cup qualifiers for Qatar 2022. And we are also going to talk about the draw for the Qatar 22. Now that most teams have qualified, we're only waiting for 3 more teams to get off the players to go to Qatar. We have an idea which groups, which teams are facing which teams. And we're going to take a look at the African representatives and see what hope they have this year. Is this a year whereby we go far or we don't go far? So keep it locked. And we might also touch on some basketball, but we'll see how time takes us.
All right. And Ulrika here is asking if we're going to talk about them slap. The slap.
No slap.
Yeah, but that's going to be in the social segment. I will let Uno decide whether we are going to talk about the slap. But here, there was the 5th ruling that was on public participation, where the majority maintained that the minimum threshold for public participation was met. That's the majority of the Supreme Court. It further deliberated that there was no obligation on IEBC to ensure that promoters of the bill complied with the constitutional requirements for public participation. There was, of course, dissenting opinions from Justices Philomena Mwilu and Smoky Dwanjala, who found that there was no evidence of public participation with respect to this Constitution Amendment Bill. So the dissenters, that's Philomena Mwilu and Smoky Dwanjala, were saying that the whole process should have been cancelled because, according to them, he said there was no evidence for public participation with respect to the Constitution Amendment Bill. But the majority ruled that the minimum threshold for public participation was met, and further deliberated there was no obligation on IEBC to ensure the promoters of the bill complied with the constitutional requirements of public participation, which now begs the question, and I want to go to the audience and the panel. And the audience, I want you to give me your comments, in the comment section. What is deemed public participation? What exactly is it? And what do you feel as a citizen that you have been involved in public participation or in a civic engagement process? When do you feel that? I want to get answers from the audience here, because I think this elephant called public participation is just not understandable. Omosh.
I think the public participation, as I understand it, is that there would be some way, form, or shape of this particular, amendment or rule or change that we want to see come across that's going to be given. There is a way that the public would be able to see, to take a look at it, to see and have an opinion one way or the other. And I think that that's where those, and I could be wrong, but I think that that's where either those signatures come in, or at least there's some way that it will be brought across as some document that you either vote on, you say, okay, we agree, we don't agree, or we've seen it. So basically people need to be able to see it, to view it, and to have an opinion one way or the other on what this is, whether they agree with it, whether they don't, but at least it's being presented to the public. The fact that it's not presented to the public like that, the 70 constitutions that was being snuck in, then basically throws that onus out, in my opinion.
But even when it's presented to the public, let's say, for example, they say we've posted this on social media or we've sent PDFs around.
Correct.
There are people who don't have internet access.
That is true.
And this is where, because a lot of people did not even get access to the printed version of this
BBI,
document.
Yes.
Yeah.
But they did say, they claimed it was going round.
They claimed it was going round.
Yeah.
But a lot of people were saying they did not, get access to it. Now we do have, a benchmark for public participation, which was the creation of the new constitution. They touched everyone in every corner of
that
Kenya.
one. They really went out.
They went out of their
that thing
way.
was printed. You could find printed copies probably even in a kiosk.
And
they really spent, it was out there.
And you see, we have a threshold, but I think the reason that there's difference in opinion from the justices, it's because there's actually no law that governs that. So if I gather, you know, like a few people in Swahili village, I can say that's public participation. If I announced it, you know, and then I gather, you know, like 50 people in Swahili village, it doesn't matter whether that area has 500 people. There's no law that's giving thresholds that this is what's required for public participation.
So there is no irreducible minimums in terms of.
Yes.
But I think the fact that doesn't having or collecting 1 million signatures, wouldn't that constitute public participation?
That's a legal requirement. That's
I'm
not,
talking about
that's a legal requirement on certain functions. There's certain functions that require, you
so
know,
let's
like
say,
a
for
million
example,
signatures.
this particular whatever the BBI outcome, this BBI, because part of it was the requirement was it's supposed to be a first-step process. 1 million signatures have to be signed. They have to collect 1 million signatures. A minimum.
That's a legal requirement. That's endorsing a document. That's not participation. Is when you're taking part in the creation. Like, this is what we want. Signing is endorsing something that has already been created. So this comes in the tail end. So whatever you're signing, were you involved in the creation of it? That is what public participation is. Signing comes at the tail end.
At the tail end. But for you to acquire 1 million, hypothetically speaking, would mean that guys were involved in the discussion. Mumekutana, mumeongea, watu wamekubaliana, and they've signed.
It doesn't mean that. A lot of these signings, a lot of the people who are signing were signing documents that they've never read. So signing doesn't mean that you're
they may have
involved in
been
the
lined
creation.
up, and each person is given
And each person is given, you know, like a
50
broad
bob,
envelope.
100 bob.
Yeah,
so
a facilitation
Yeah.
fee.
Because ideally, you know, public participation should be, you know, you have a town hall, people come in. I mean, that's what, unless there's another term, you know.
So, but the problem is that there's no threshold. So
Right.
I can decide, you know, like I gathered people at the OneMic show, and that's public participation, and it's left to the opinion of the justices. Because you see here, there are some justices who said the minimum thresholds were met, and there's some justices who said no, there was no public participation, you know, like the minimum thresholds were not met. So it's a matter of opinion. So it's gone to the majority.
So now there are so many comments. My goodness. But you know what? We encourage guys to keep on ongeeni huko tu hiyo kwa mtandao.
So I think Slay is saying, I think public participation involves more than just voting. DJ Tucha, it also involves speaking out if something does not sit right or questioning things. Okay, so that's an interesting point. And then DJ Tucha says, common Mwananchi will not read that. Civic education is needed in forums where, like, someone from the government explains the document means to the everyday person. And this was happening under the new constitution. They were going to churches, they were going to markets, they were going to all kinds of places.
there is no place those guys were not
Yeah.
in. No place.
Which means that they could duplicate the same effort.
Yeah, they were even in Koinange Street.
but
you know, you'd
remember,
find them in Koinange Street in the middle of the night.
BBI, one of the bigger issues with BBI is that it really was not a budgeted item, and as opposed to the constitution. It's like they had to find money for BBI, so they were not. I think they were trying to go in underneath the radar without going underneath the radar. Because, of course, now when there were dissenters or people who are saying, hey, this BBI thing, they're like, okay, first of all, mumekula do. Na hii do mumetoa wapi? Because haikuwa kwa budget.
Walionewa 18 na walionewa midfield.
Yeah, hii kitu haikuwa kwa budget. So hizi do, ni kama mumeenda mkasanya mahali.
Yeah, but there's a lot of also government resources that were being used, you know.
Of
like
course,
correct.
and that was a problem. I think
correct. Yes,
the justices mentioned.
And Tommy here mentions.
Sneak in.
Yeah. So Tommy here mentions an important aspect where he says there's also a public participation bill sitting in Parliament. Signatures are not public participation, and I agree with Tony on that. They just validate that it's worth looking into. So there's a bill sitting in Parliament, a public participation bill. It's currently not law, and these are some of the issues that Parliament has been slacking on, and that's what's creating these problems of interpretation.
And the public participations. What about if they do those to town halls, these barazas that was there and stuff like that? See, that is public participation.
That is public participation, but there has to
But
be
there's
a
no
framework.
threshold. Like you said, people can kutana via people's kamkunji hapa kwa make sure and say that was public participation.
Yeah, what constitutes that? How many people should be in it, or how do you call it a quorum when it's 3, 4,
And then
5?
and then they can use like the county commissioner's office, the chiefs and the sub chiefs, to do that, to have those barazas and those stuff in the meeting, and it becomes like they were doing with the banana chungwa during the chungwa banana chungwa banana constitution amendment time. I remember they would say they were participating in public education through that. They will call for barazas for chief and somebody comes with that blue book and tries to sum up the constitution. They can do something like that and say that's public participation. Right? There are ways where they can beat or they can come and justify that there was a public participation in it.
Yes.
And I agree with the bill not being there, defining a clear definition of public participation. There are so many loopholes on how they can get that public participation without actually being public participation.
Ndo hivyo sasa, like you can do a baraza even with 1,000 people, but a justice can decide, one justice can decide that is not enough because there's no benchmark, there's no law. So I think that's something that needs to be looked into, and they need to fast track that law before we get into the next election. I mean, I know right now the priority is on presidential elections, and then DJ Tucha. Let me see here.
Ziko nyingi.
These are so many comments.
Ziko
My
nyingi.
friend, wanaongea huko tu, wanaongea, but it's good. Again, we encourage conversation.
Yeah. So as we wrap up here, like we can see, like there's, like on this public participation part, there are no laws that exist. So that's something that needs to be looked into. Now, the 6th ruling, which was like the final ruling because the 7th one was indecisive, the 6th ruling said that the IBC had the requisite 3 commissioners, which is the minimum constitutional threshold required to perform their functions. Remember, IBC has a maximum of 7 commissioners. Now, this ruling was dissented by Justice Mohammed Ibrahim, who said the IBC Act set a minimum of 5. So I want to explain this a little bit. So the Constitution said for the IBC to be in quorum, out of those 7, as long as you have 3, they can operate and function, conduct by elections, registrations, nini. But then, that same article also said that, like Parliament will create a law to effect this article. So Parliament went and created the IBC Act. Now in the IBC Act, they declared that the minimum, they raised it from 3 to 5. So 5 was the legal minimum according to the IEBC Act. Now, in the majority ruling, effectively overturned that portion of the IBC Act that requires a minimum of 5 IBC commissioners. It said that the one that stands nearly a constitution, only 3 commissioners required, and that's good. And I think this was a very judicious decision, because had it gone the other way, had they said that 5 commissioners were required as per the IBC Act, that means from the moment that IBC had less than 5 commissioners to the moment they appointed and got more than 5 commissioners, everything that the IBC did during that period of time would have been null and void. This means by elections, it means registrations, it means everything, any functions that were performed during that period would have been null and void. So I think here they're also looking at, yes, they're looking at the Constitution and the law, but I think they're also looking at the impact that this might have. But that didn't stop, some justices from dissenting, because I think the dissents here were, did they have dissents on this one?
Ibrahim.
Oh yeah, Justice Ibrahim. Yes, like I said, Justice Ibrahim is the one who dissented, and he said that the view that the IBC was enacted to give effect to the Constitution. Hence, the courts ought to give effect to statutory provisions unless the same is declared unconstitutional. He therefore found that IBC was not properly composed or correct at the time of verification of signatures. He, however, held that since IBC was relying on some case which remained unchallenged, it meant that the actions it took in the intervening period were lawful. So Justice Mohammed Ibrahim felt that the IBC Act should have taken precedent over what was said in the Constitution of 3. So another interesting, and this right here also, the majority ruling is it asserts the court's powers in striking down laws that have been written by Parliament. Because think about it right now, there might be so many laws sitting in Parliament that are unconstitutional that are just waiting for a challenge. Imagine, talk about laws barring dual citizens from becoming ambassadors. There's actually a law right now under the Foreign Service Act, and maybe Tommy can tell us a bit more about that. But there's a law that actually now bars after the Korean ambassador incident.
Yeah,
Mwende.
Yeah.
So Parliament went and created, they actually created a law that now bars dual citizens from holding ambassadorships positions. I strongly believe that law is unconstitutional, and so are so many other laws that are sitting, as laws, just waiting to be challenged in the Supreme Court. And then the last one was on whether questions were to be submitted as separate and distinct referendum questions. Could you bring all those 70 questions just as one yes or no, or do they all need to be distinct, like the ballot initiatives over here?
Yeah, where they do the individual ones. Are you voting for Sijui,
Yes.
I don't know, the firehouses, Sijui
Yeah.
for teachers, for library, for
Yes.
Sijui Nini?
So on this
Roads,
this was another win for pro-BBI people, because the courts said this is not ripe for determination. That's a new word that I learned that's being used in legalese.
Ripe.
It's not ripe for
Yes, it's not mature.
Yeah, because
Mature.
IBC had not, questions had not been formulated by IBC. So they can't rule on something that has not actually happened. So this is still open-ended. But I would tell the pro-BBI people to be careful, because it doesn't mean that when they do it, that the Supreme Court will say yes to it if it's challenged. So that's another thing that they need to be careful about. One last comment here, let me read from Tommy. He said, I participated in amending the Election Act before the runoff that was open to the public and televised. It was held at County Hall and televised. You come in, you say your piece, and give them the written version. Now, here's where, Tommy, I'll fault you guys, and I don't call this public participation. Why do I say that? This thing of doing things in Nairobi, like everyone lives, it's something that's affecting the whole country, but something has been done at KICC. Something has been done at County Hall. And then it's called, that's not public participation. That's KICC and County Hall.
Threshold.
Yeah, especially if it's an issue
Threshold.
that's touching on the whole, and that's why this law needs to come. This public participation bill, it needs to come, because a lot of times these people say that, oh, you can bring your comments at KICC. Kwani all Kenyans live in Nairobi?
Threshold, my
But
friend.
so
Threshold.
that was a call out to everyone in the country. They were not doing at TCG. You go to Western, you go to whatever. Everyone was supposed to come to KICC.
Now, I don't know,
That's
but
what I'm asking.
that's according to Tommy. Maybe Tommy can
not-
tell us.
Maybe that was probably part if you live in Nairobi. I'm hoping.
So
That's
so-
if you live in Nairobi.
But an Elections Amendment Act is affecting the whole country.
Yes. So, for example, probably, I'm assuming that Tommy, like if that was happening there, they set up a place for people who live in Nairobi to go to KICC. We don't know if they had a setup in some city or they had in Europe.
I can guarantee you there was no setup in Turkana.
At least chaps in Kilifi didn't see it.
Yeah, maybe
I'm just curious.
Maybe
No,
even
because
Kilifi,
maybe Tommy
maybe
can
even
carry on.
Kilifi, they might have a setup. But I can guarantee you there was no setup in Turkana. I can guarantee you there was no setup in Isiolo. I can guarantee you there was no setup in
The
Wargadoo.
roads were still bad in Western.
Yeah. So
not fixed
so again, and this is where these games of public participation, which politicians don't manipulate because there is no law. And I think
But it's back to this irreducible minimums. They don't exist.
they don't exist.
And that's where these guys, okay, yes, our people, work out these constitutional frameworks in place. Now we need meat and potatoes. We
Yes.
don't need the hooves and the what was it?
And the
hooves
horns.
the
Horns.
Yeah.
Yeah, we
Maybe
need
the
them.
tail, maybe.
And do the eyes.
The whisk
Yeah,
and the
we-
tail. No. Hey, wait, no. The hooves and the horns. That's all that was left.
We need
Yeah.
more. And I mean, it's been 12 years. We need more.
Yeah.
These things should have. It's almost like I think they almost literally need another commission to sit down and now start coming up with guidelines for the things that are actually present. And then the ones that we don't have, then now you come up with this so-called BBI type thing where you now push. To me, I think that go back, look at what we have, which goes back to Arap Mashamba, who was saying, no, let's look at what we have and fix them. And I'm with him on this one. Fix the ones that are there, give rules and guidelines. Don't give us a framework. Give actual specifics. Like this is how it's supposed to be done. And then we've put all those things in place. The ones that are missing or that need to be changed those are the ones that we now put into these so-called popular initiatives.
Okay, and Randall says, I live in Nairobi, so I went to Nairobi nationwide. Is possible. There's a system set up to the ward level. The issue might be funding. So what Tom is saying is that it did not happen in those other places. That's what Tom is saying.
No, he's not saying that. He's saying
that. He's saying that without saying it.
He's not saying that. He's actually saying that there may have been an issue of funding. However, they do have the systems in place that it's set up that way. I think let's take it, for example, the voter registration, like the way they were doing the voter registration thing. And at some point, you had the, what was it, like about a week or 2 weeks? It was about a 2 week period where they were doing countrywide voter registration, right?
Yeah.
Then at some point it came down to like, okay, Sasa,
To constituencies.
now we've stopped doing that. Now you're going to have to go to
a constituency office.
Yes, you're going to have to go to or a Huduma Center or whatever it is, or it's a place that's been set up. So that's what Tommy is saying, that basically they do have that system in place. They may not have had funding to bring it down, and he's not sure.
Yeah,
I think that's
so
what he's saying.
so I can tell you these meetings don't happen in Turkana. They don't happen in Wargadud. I can tell you that.
Boss,
They mostly
is there
happen
a
in
road that
Nairobi.
even takes us to Ouagadougou?
They mostly happen in Nairobi, and like a lot of these things that you bring your proposals to KICC.
Of course.
Come on.
I will.
Or bombers. It's
I will
actually
be-
normally bombers.
I will be that guy that says they probably did. It's just that people. Yeah, they probably did. I'll just leave it at that.
No, the reason
Just
why,
for the sake of being the anti guy.
the reason why I'm sure they didn't happen is
I think
because
probably Wajir had.
the reason why these things didn't happen is because they usually never, and there's no minimum threshold. You can go meet
And
people at
that's-
KICC.
yeah.
You can go meet people at KICC or County Hall or Bomas and call it public participation, and that's why there's certain minimum
So threshold.
that are required.
So
Yes.
today's new word is threshold.
Threshold and paradigm shift.
Allah.
With that
I
said,
don't know how we got to paradigm shift. This
By the
guy,
way,
this guy,
we checked from ripe
yes,
to ripe. Okay.
to threshold.
Threshold. Okay. Paradigm shift.
Paradigm shift.
Because he's the one who's shifting the paradigms right now.
Like a nonsense.
Yes.
no, and I'm gonna use it in a sentence.
You can use it in a sentence, but then also what the other thing that Tommy was saying, which is interesting, to meet your so-called threshold word, it was televised.
Not everyone has access to a TV.
Hey, again.
How do you know that?
Hey,
No,
again.
I
You
know.
live in Turkana.
I know because I have family members who don't have access.
in Wargadou.
May-
No,
may-
No.
maybe-
In Wargadou, in Turkana, your
no,
family members in
no,
Turkana?
In
no,
Wargadou.
even in Nairobi. I'm talking
No.
about Nairobi, Uno.
You've mentioned Turkana. Do you have family members in Turkana?
Yes, I do.
In Wargadou.
In Wargadou.
Yes, I do.
And they don't have TV.
Yes. So
And-
here's the thing,
and
Uno.
the road is bad.
And he's confidently saying,
Yes.
but it's
No, he
out.
has.
Yes, absolutely.
But see, this guy,
You know-
we know,
you know-
we know where it comes from.
You know, Kwanzaa,
Oh.
let me tell you, Kwanzaa,
sorry.
Nairobi, what people don't understand about Nairobi,
Correct.
Nairobi is 65% informal settlements. 65% of the population.
That's actually
So
true.
that's almost 7 out of 10 people who live in Nairobi live in informal settlements.
That
You know,
is
they don't
actually
live in
true.
Kilimani and Sijui, Nairobi West, And I think, you know, part of the reason why people sometimes, like even myself, for a very long time, I didn't realize this.
Micah is part of one of 7 out of 10. Micah is part of what? The 3 out of 10?
3 out of 10.
Okay,
You're also part of the 3 out of 10.
I mean himself 7 out of 10.
No. You're part of the 3 out of 10. You're part of the 3 by informal settlement.
He's a guy of Ongem.
By informal settlement, I mean a place that does not have access to running water, a place that does not have access to power. You know, like
electricity.
Yeah, that's almost 70% of Nairobi, which is a very big number.
Okay.
So
70%.
yeah, so there's a lot of issues to be factored into. But anyway, we've gone over time here.
Way overboard.
Yeah.
I think you need to read the comments.
Yes.
Then we can.
Okay.
Because we have comments over here for days. I think
so Slay anasema Tom anasema Turkana people still see the MPs and MCA. How did they get there? And then Slay anasema tunga sentence ukitumia neno threshold. And then here
forget threshold, paradigm shift.
Kulikuwa na sentence ambayo ilikuwa na threshold ya paradigm shift.
And then Steven anasema people don't watch TV in Nairobi and it's the middle class people I'm talking about. I know a few. Slay, does water rationing count in this? Because okay. Anyway, with that said, this is it for the News and Politics Hour. This is more like an hour and a half. But I want to thank the panel for their candid contribution. This is a very important topic. You know, this is a very once in a lifetime type of topic, and that's the reason why we really wanted to dig down onto it. But we want you to stay tuned for more coming up. Uno, please remind the viewers real quick what we'll be discussing in tonight's social segment, and if we're going to talk about the slap.
No, we will not talk about the slap. But we're going to address, you know, the English and how much. I'm sure most guys have watched the show on Netflix featuring young, famous and African, or African, young and famous something. The title just that one, and we specifically, you know, we let us just say, you know, is like Ali said and posed the question, is there a desire to want to be accepted, you know, when you are fluent supposedly in English?
Not just the language, but also fluent in the accents.
The language and the accent, enunciations and the pronunciations and all that schmick. Keep it locked. I mean, I'm sure some of us over here, even over here in the chat, and you know, you hear Ari say something, or when Ari says the Buddha, mnaza kucheka, mnaza nini, lakini matamchi ikona chida. Or is it ikona sida?
Chida. You know, the interesting thing about Kenya is that we have all kinds of accents and pronunciations. There's a L, there's a R, there's a P, there's a B. We have all of them.
But here's the interesting thing. The Japanese will do ero and ara, it'll be very cute.
Rosafi.
Lakini Mogekoyo kifanya ara ero.
Japanese hata umeenda far. Tanzanians.
By the way.
Tanzanians do it all the time.
Anyway.
Yule jamaa. Yule.
Yule pale.
Mimi ni yule. Yeah.
Anyway. Put it this way. Keep it locked. Tell a friend to tell a friend to tell a friend that the people's Kamkunji is in full effect. DJ Machachari, who does not have any fish right now. Buddha boss, kade. Togende.
Shida zangu nimetupilia mbali, hapa ni mitungi na mnazi na meshekelewa inachoma dijua leo na washafunga ngoma simanze kulia kinashirua pitie uko na fruits kwa simu taxi walipie sivyo yuko wapi mwambia rakishe na zile kreti za bia zifike tunapewa tunalemba tunapepea tunahemea wajanja no akinemelea leo hakuna konyunga tusherekea tuko sherehe sherekea tuko sherehe sherekea tuko sherehe sherekea 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 tuko sherehe sherekea tuko sherehe sherekea tuko sherehe
Shajikoki kama tembe nimebeza kiunokata kama reza. Stop with the teasing, acha kunionyesha baby, basi rope kama dam. Baby, I'ma blow my money like Saddam Hussein. Girl, you know you better than him, baby. Girl, nobody better than you. Only you, only you. Nobody better than you, baby, you, baby, you. Yeah, chako cha moto place nachomeka. Up and low, come on, now be better. I'm running first, I'm running late. I can't wait to put it deep. Baby, unani peleka na race. Baby, the way you want you always. Moyo na dunda ni kama na de. You want to tell me again and again. Baby, see me, tanya. Wako picture,
omugenze kyamuse butagala ndongo ekirala kyamututte kwesiba nnyo ku bantu. Hello, ndieno nsibudde. Hello, ebakyali tuteredde. Hello, betuli eno tusimbudde. Hello, ebyokunywa tuteredde. Leta mwana watu somba omuziki mpaka kunca. Gambye tonyumiza mbwateroni ebisigadde binaaba byanca. Byana biwa njagala nyere mbirabe nsimbire njiwa. Amanja mumanyira munengeriza kikimuba musukaga. Let's go. Go night boy squeeze more. Chuck it, check it, check come out. Zora yankuwe webwa zikube webwa wa zikube webwa. Hello, ndieno nsimbudde. Hello,
aikusidosto huyo mimi nina kama manze huko nje naitwa 1 minute man. Ati mi uboba tamon high demand. Depression ikikikin manze nitakiban. Kishash kobash kishash kobash kishash kobash kishash. You want a quickie in an Uber chap chap. Allah kama soja boy she makes it clap clap. Hii samosa ni kama nzi yako. Ai venye ina slap kishash kishash kwa bash. Kishash kwa bash. Kishash kwa bash. Kishash skiza everything you say has a consequence. Anatingisha ungedhani ni effervescence. Manzi yako yeupeana na confidence. Amjidena man I feel like a classic man. Amekata tatu na bado wa bleki. Ni kama gari imeachilia breki. Na manyaru zitafanya mini kreki. Nikasupuka poa kakona jegi. Ai usidoz ndo huyo mimi nina kam. Manze huku nje naitwa 1 minute man. Ati mi uboba tamon high demand. Depression ikikikin manze nitakipan. Kishash kwa bash.